Further hearing in the appeal Bannerman Town against Eleuthera Properties.
Mr. Rowe, before you start, can I just put a question to you, which I would not expect you to answer straight away, but which we would welcome an answer from both parties to at some convenient time in the course of this morning. So the barring provision, how long does that last in circumstances where no certificate of title is issued? One possible outcome of any of these cases is that the court declines to find that either party before it had title. Now, if that is the position, does the barring of third parties who failed to turn up to assert a claim then fall away, or does it survive indefinitely with the result that one would have to conclude that the land belonged to nobody at all? And I don't feel that you've got to give an instant answer to that question, but it's a question we would like answered at some stage.
Yes, well, I'll certainly give that some thought. Your Lordship said in the course of the morning it might be something that, if Your Lordships will let us do, we could put in a note.
Yes.
We send in after the
If you're
hearing.
in a position to give us an answer this morning, we will be impressed and delighted. If not, then obviously you must both have an opportunity to address it in writing.
Grateful. Well, Lord, I'd got in my submissions, I think, as far as about halfway through my seventh reason for saying that the first argument, argument one as we've called it, in support of the association's claim doesn't work anyway. And I'm going to try and pick the pace up a bit because I've got to get through a few more points on that and then also move on, of course, to the claim that EPL made and why we submit that that claim was a good one and was on whichever basis properly upheld by the courts below. But so far as the association's claim is concerned, I did want just briefly to deal with the point about that we make about the creation or the attempted creation of a non-charitable purpose trust. You'll recall that our original case, we said there were two difficulties with the assignment to the association. One was the rule against perpetuities, which we recognise doesn't work in the light of the abolition of the rule. But the other is the attempt to create a non-charitable purpose trust. And can I just, for that purpose, take Your Lordships briefly, if I may, to the Memorandum and Articles of Association of the company, of the association. They are relevant because the terms upon which the property was purportedly conveyed to the association included a term that the property be dealt with in accordance with the Memorandum and Articles of Association. The reference is Volume 2, page 756. That's where the memorandum begins. And you'll see that various objects are set out, encouraging land ownership, obtaining government approval for the transfer of land listed as generation property to the association. That may be a reference to the fact that around about this time there was a bill, I think, before Parliament, which would have put generation property in some sense onto a statutory footing, though that in fact didn't happen, hasn't happened yet. Survey and subdivide the land, etc., etc. That's any land that they did get under some arrangement like that, and various other objects. But what's relevant for present purposes for my submission is clause 11 of the memorandum. What happens on the winding up or dissolution of the association, i.e. of the company? It's a company limited by guarantee, as you'll see. If there remains any surplus, then that shall not be paid to or distributed among the members of the association, but should be given or transferred or applied to some other association, etc., having objects similar to the objects of the association, or to some one or more of the charitable objects of the association, voting at a meeting duly convened, etc., etc., or in default thereof, the Chief Justice has a role. But the essential point is that...
I mean, that assumes that the association has some charitable objects.
Yes.
Which is...
Queer.
Yes. Well, okay.
It may or may not, but yes. But the point I draw from it is that, as you'd expect from a not-for-profit company which is limited by guarantee, the members don't get anything even on a winding up of the association.
Yeah.
So they have no interest in the assets of the association that they can ever get their hands on. And to like effect is Article 70 of the Articles of Association, which is at page 773. Lord, why is any of that relevant? Well, could I ask your Lordship to turn up Reacher's Will Trusts, which is Volume 2 of the main bundle of authorities, tab 51.
The page references?
Sorry, my Lord, page 8876. This was a case about a gift to the Anti-Vivisection Society, as it was put in the gift, which in the end failed because the relevant thing didn't exist anymore. But at some stage in the argument, it became relevant to consider whether a gift to the London and Provincial Anti-Vivisection Society, if you could read the gift as such, would have been a valid gift. Mm-hmm. And that was a non-charitable, unincorporated society. And can I ask your Lordships to pick it up at page 8887 in the judgment of Mr. Justice Brightman. He quotes towards the bottom of that page at letter F from Leahy and the Attorney General for New South Wales. A gift can be made to persons, including a corporation, but it cannot be made to a purpose or to an object. So also a trust may be created for the benefit of persons as Setiki trust, but not for a purpose or object, unless the purpose or object be charitable. For a purpose or object cannot sue, but if it be charitable, the Attorney General can sue to enforce it. And that's, of course, the underlying rationale of the rule. Mm-hmm. There's got to be some beneficiary who can sue to enforce the obligation. And then if we move, if we may, across to the right-hand page, or page 8888, letter E, the judge says, a trust for non-charitable purposes, as distinct from a trust for individuals, is clearly void because there is no beneficiary. It does not, however, follow that persons cannot band themselves together as an association or society, pay subscriptions, and validly devote their funds in pursuit of some lawful non-charitable purpose. An obvious example is a members' social club. And he goes on to say it's not essential that they should only intend to secure direct personal advantages to themselves. And I can probably skip forward a bit through this to the next page, 8889, letter B. And if we pick it up around about letter B, the resultant situation on analysis is that the London and Provincial Society, which was the thing that he was contemplating whether a gift to that would work, represented an organisation of individuals bound together by contract under which their subscriptions became, as it were, mandated towards a certain type of expenditure, as enumerated in Rule 1. Just as two parties to a bipartite bargain can vary or terminate their contract by mutual assent, so it must follow that the life members, ordinary members, and associate members of the society could at any moment of time, by unanimous agreement or by majority vote of the rules so prescribed, vary or terminate their multipartite contract. No limit to the type of variation or termination which all might agree. There is no private trust or trust for charitable purposes or other trust to hinder the process. It follows that if all members agreed, they could decide to wind up the London and Provincial Society and divide the net assets among themselves beneficially. No one would have any locus standi to stop them so doing. The contract is the same as any other contract and concerns only those who are parties to it, that is to say, members of the society. And then he goes on to consider what about gifts to the society. The funds of the association may, of course, be derived not only from the subscriptions of the contracting parties, but also from donations from non-contracting parties and legacies. And then importantly this, in the case of a donation which is not accompanied by any words which purport to impose a trust, it seems to me that the gift takes effect in favour of the existing members of the association as an accretion to the funds which are the subject matter of the contract, which such members have made into say, and falls to be dealt with in precisely the same way as the funds which the members themselves have subscribed. So in the case of a legacy. In the absence of words which purport to impose a trust, that important qualification again, the legacy is a gift to the members beneficially, not as joint tenants or as tenants in common, so as to entitle each member to an immediate distributive share, but as an accretion to the funds which are the subject matter of the contract which the members have made into say. And he goes on to say that the legacy could be construed as a legacy to the London Provincial Society on that basis. The point, of course, as your Lordships will have gathered behind it, is that in the absence of a declaration of trust, if you give money to or give a legacy to an unincorporated association, then that works, even though it's non-charitable, because it takes effect
contractually
as a gift to the members, albeit the position is complicated because the members, by virtue of their rules, don't immediately get a share and can't insist on having their own share taken out, but they can collectively take it all out.
lay hands on the money unless there is an agreement to vary the contract.
I'm sorry, my lord, they can't. I didn't
They
hear
can
the first
never
part.
lay hands on the money unless
No,
there's an agreement
that's right.
to vary the contract.
Yes, but the reason that it doesn't fall foul of the rule against non-charitable purpose trusts or gifts on not gifts
Is that
declarations is that they could.
Yes.
They could ultimately all decide to do it. And so in the present case, I submit a gift to the association by itself would be okay, but the critical qualification is in the absence of words purporting to impose a trust, because what's done here is that the conveyance expressly stipulates that the property is to be held on trust to be dealt with in accordance with the Memorandum and Articles of Association. And those the Memorandum and Article of Association, which, as is inherent in the nature of this company, prohibit doing the one thing which on the analysis in Reacher's Will Trusts saves it from being a gift for a purpose, because the members are not allowed, even on a winding up, to take any benefit for themselves. Of course, it might be said, well, they could always amend them. They could always unilaterally agree, or collectively and unanimously, rather, agree to amend the Memorandum
process would be identical to the process that would be involved if there were no words imposing a trust.
The process that they would adopt would be identical, I agree, but that would be inconsistent with the terms of the trust, because the terms of the trust say it's got that the property has to be dealt with in accordance with the Memorandum and Articles of Association.
As the Memorandums are now constituted, and if the Memorandums have their own internal provision for variation by an appropriately qualified majority,
well,
they would simply amend to say the money upon the winding up shall be distributed to the members.
Well, I think there are two answers to that, my lord. First of all, that I don't think there isn't, in fact, any provision expressly in the Memorandum of Articles, I don't think, for, if there is, I've overlooked it, for
you need an
amendment. But there wouldn't need, I mean, I agree, as a matter of corporate law, there wouldn't necessarily need to be, because you can do, all of the corporators collectively, as long as it's all of them, can do whatever they like. But that would still, in my submission, be inconsistent with the stipulation that the property had to be dealt with in accordance with the Memorandum and Articles of Association.
Why would it be inconsistent? Because if you amend the Memo and Arts, it's still being applied consistently with them, albeit that they say something different to what they said at the time when the trust was set up.
I see that point, my lord. I think the answer is, I have to say, but in my submission it is a fair construction of it, that it does by necessary implication mean as they stand at the moment, and it doesn't contemplate. I can see it might contemplate minor variations, but to suggest in my submission that the gift contemplates a complete volte-face on the part of the company, so that it ceases to be a not-for-profit company in which the members have no
well, how does one
personal
define
interest.
this? I mean, you're not, as I understand it, saying that they couldn't vary the purposes. They couldn't add a further purpose which became relevant as a result of some change in the underlying situation. You're not saying that.
I think I'd have to concede they could do that, my lord,
okay.
yes.
Well, so you need some workable definition of what they can change and what they can't. And your assertion seems to be they can't change things so that it goes into the purpose becomes to empty the money into their pocket. Now, I see the coherence of that if one's talking about charitable purposes, but we're not. So why can't they do that? Why can't
Its coherence doesn't depend, in my submission, upon whether the purposes are charitable. That the purposes are altruistic. What's important about them?
For them to divert them into their own pockets.
What's important about the purposes? What's the characteristic of the purposes? Is that they're altruistic,
but
rather than acquisitive of money.
we can't be sure what sort of trust Mr. Justice Brightman was thinking about, because I think he was just, as it were, putting a trust on one side because there wasn't a trust in that case. But it may be that he was just thinking of a trust for the purposes of the unincorporated association, and then one can quite see it would be an invalid purpose trust. But if it's simply a trust to be dealt with in accordance with the contract between the members of the association, i.e. the Mem and Arts, then why would it differ from a gift to the members pro tem to be dealt with in accordance with that contract?
Well, my lord, I agree. I can't derive from from Mr. Justice Brightman's judgment exactly what sort of trust it's necessary to impose in order to call into effect the qualification that he puts on his judgment. That's got to follow as a matter of principle.
But we know what he was thinking about, which is a non-charitable purpose trust. So he was probably thinking on trust for the purposes of the association.
That may be a reasonable inference. But anyway, your lordships have my submission. I say that it is a reasonable inference as a matter of, on the ordinary principles of construction of contractual documents, that one thing which is not contemplated and is therefore not permitted within the expression to be dealt with in accordance with is the complete transformation of the association from an altruistic body into one which simply enables the members to divide up the assets among themselves, so that the company ceases to be a not-for-profit company and becomes a company from which they can derive money. But I must make a bit of progress, of course, my lord. Our last point in relation to argument one is simply that it wasn't anyway Charles Roll's evidence that he was the only one left in occupation of the property. For your lordship's reference, I'm not going to turn it up now, but it's volume 9, page 5222, 95222. Since your lordship's how I'll go to it.
Volume 9.
5222.
Thank you.
Is there anybody on the property now farming? It's that passage. This is cross-examination of Charles Roll.
Sorry, 9522?
No, sorry, my lord, 5222.
522.
5,222.
Right.
9 was the volume number, but got that.
Right.
Short point is he talks about Jimmy Wilson and Hubert Forbes also. He says farming somewhere on the land. Neither of those two persons have purported to assign anything to the association. So, well, that was argument one, i.e. it all comes from Charles Roll. Argument two was to do with the Tom and Miller Corporation. It was only fairly faintly advanced by my own friend in his oral submissions, but rightly in our respectful submission, because the Tom and Miller case, Tom and Miller's case, of course, was completely contradictory, as I hope I've managed to demonstrate, of the association's case. It was a claim that 31 persons had collectively the whole interest in the land, nothing to do with descendants at all, on the way it was put in their pleaded claim. So it's at odds entirely with the association's contention. And it's also true to say there wasn't in fact any evidence, although there was no direct evidence of the assignments. I take my friend's point about the fact that it was recited and there was an explanation given, but for what it's worth, there was no direct evidence of the assignments. And in any event, if I'm right about my points concerning non-charitable purpose trusts, then the same applies to the Tom and Miller conveyance as well. My Lord, then argument 3, which is the argument that the association has taken a conveyance of the interests of the members of the association, which is presumably a reference to the conveyances from everybody as opposed to just from Mr. Roll. This essentially suffers from the same difficulties in our respectful submission. I won't go through them all again. But it also doesn't work in our submission for the other difficult reason that if it's right that actually everybody, even if they're out of possession, who is a descendant is, or rather even if they're out of occupation, if they're a descendant, they're in possession vicariously through whoever happens to be left amongst the descendants. If that's right, then how does a conveyance by the ones who are in possession have any effect? One would need, presumably, to get a conveyance from all of the descendants. It highlights the difficulty with the association's argument and why it tends to oscillate between saying, on the one hand, the people in possession are the descendants who are present on the land, and on the other saying the people in possession are all of the descendants, with the ones who are on the land doing so on their behalf, or the ones out being in possession through the ones who are on the land in some fashion. So, my Lord, for those reasons we submit that our argument 3, as we've called it, doesn't work either. I was quite rightly asked yesterday by Sir Rupert Jackson, what about Mr. Justice Adderley's, or Justice of Appeal Adderley's dissenting judgment? There are a few points to make about that. First of all, I don't think it is right, actually, that Justice of Appeal Adderley is the same Adderley who was the lecturer referred to in the Ambrister case. I think that may be where your Lordship's reference came from to his having done it.
That was just an inference I drew.
Yes, no, well, it derives from, of course, the common law habit of not revealing judges' first names unless, unless they've appeared in some other capacity or whatever. But so, no, there is an Adderley who is referred to in Armbrister as having given a lecture about, at paragraph 10 of Armbrister, about quieting title and land thieves, and having looked into that.
And the judgment says that he was a great expert in these matters and a senior member of the bar.
Yes.
So I rather guessed he might have then been promoted to the bench.
Yeah, no, well, that was Paul Adderley, the late Paul Adderley, who was,
Right.
he was, I think he's the longest serving Attorney General of the Bahamas.
Really?
And so he's, amongst many other things, including, I gather, for quite a long stage, counsel for my clients. So, but anyway, that's beside the point, I suppose. But anyway, none of which is to say that Mr. Justice, or Justice of Appeal Neville Adderley, is not a distinguished judge, but he doesn't have the particular specialism in that field necessarily that one might have inferred from the name. What about his judgment, though, on its merits? Well, the short answer to that, in our respectful submission, is that he does not confront in his judgment any of the substantial difficulties with the association's case, which we have sought to outline. He doesn't really anywhere properly confront whether it's appropriate to reverse the judge's findings of fact concerning the lack of any joint intention. And in that context, the Lordships have our submission, I'm sure, about that, but we say that the judge's findings of fact were prefaced by a perfectly correct direction as to the law. It's true that at one point she does say, I think Lord Briggs pointed this out yesterday, that it had been accepted that the burden was on the association to displace, to show that they dispossessed the paper title holder. But in fact, if one looks at the whole of the law that she cites, prefacing her judgment about the joint intention point, she's directing herself squarely in accordance with Powell and McFarlane. And she is not setting some different test. She's considering, in straightforward terms, was there possession of the land by the associations, the people through whom the association claims. And it's true that she
may have wrongly assumed that it was conceded that you had paper title.
It looks, well, yes, I'm not sure whether that's what she might have been, because it's preceded by a section where she finds that there was paper title. So yeah. what she might have been saying was it's conceded that if they've got paper title, yeah, okay, then that's what needs to happen. But there's scant evidence in the judgment that makes a difference as to the way in which she reviews the facts or affects the correctness of the conclusion to which she comes. I think it's also, it may also be said in my friend's reply, because he had the kindness to let me have a little written note of it, that the judge was wrong to rely on Mr. Justice Higgins's dissenting, as we now know it to be, judgment in the Brown case. the Faulkner case, as I think it's called. Our respectful submission about that will be, and my friend will develop the point, I'm sure, when he makes his submissions, but our respectful submission about that will be that the statements of the law that Mr. Justice Higgins gave were not incorrect in any way. He was quite right to talk about what you need to establish if you want to get home on a claim of joint possession. And the fact that Lord Chief Justice Carswell took a different view as to whether the judge had been right on the evidence to find joint possession is neither here nor there. But I'm sure you'll see when you come onto it, but he said in fairly lukewarm terms, one might question the sufficiency of the evidence to found a joint possession, but not sharing the advantages of the judge, etc. He didn't overturn it. So, my Lord, that's all I think I want to say about the association's claim. What about EPL's claim? Well, there is a procedural point about whether it was proper for that to be considered at all by the court. And I think it's now accepted that there's nothing in principle to stop the board from upholding the Court of Appeal's decision that a purely possessory title had been made out. I think at one stage, put at its highest, the submission on the association's behalf was to say it wasn't open to the Court of Appeal to do what they did at all. That, I think, has now been replaced in my friend's submission by the suggestion that it affects the way you should look at and deal with the Court of Appeal's treatment of the issue. But for completeness, my Lord, we do, first of all, respectfully say that it is open, even if there had been an express disavowal of any claim other than one based on paper title, it would still have been open to the Court of Appeal to say, well, on the evidence, we nevertheless think the right answer is possessory title without paper title. And we've cited in our written case an instance of that happening. I appreciate it's in the US Supreme Court, but that doesn't really touch on the jurisdictional point. It is something which is open to the court in my submission, unless, of course, there is a particular procedural unfairness about it, and I'll come on in a minute to deal with that. The court must follow the material where it goes, and that's particularly so, we would submit, in this context, where there's a public interest in the court coming to the right answer, because the judgment doesn't just affect the parties. It's a judgment in rem. But in the present case, in fact, the extent of any procedural unfairness because of this is extremely limited in my submission. And can I just take your lordships to a few documents to demonstrate why I say that? If we go to the petition, first of all, my Lord, which is in volume 1, page 16. We can see, your lordships will have seen this a few times, I'm sure, but your lordships will recall that the petition says...
Sorry, can you give me the page?
Of course, my Lord, it's volume 1, page 16. The petition itself says your owner your petitioner rather is owner in fee simple in possession by virtue of a conveyance dated, etc. And then we cut through a lot of stuff to the last 2 lines of that paragraph, and by virtue of its possession from 26th October 1988 to the present time of the said land. Now those last words, of course, were entirely redundant if EPL were saying if we don't win on documentary title, then please dismiss our claim. We only want a claim in documentary title. They weren't necessary at all.
The case basically rests on what was said.
Yes, and I'm going to come immediately to that. I set that out as the context, though. What in fact, of course, they were seeking to do was to take the benefit of the presumption of possession, having taken, as they were contending, a conveyance of the land from somebody who was entitled to convey it. My Lord, we can see that if we go back to volume 9, at page 5324, my Lord, it's towards the bottom of that page, line 21. I just want to stop and emphasize that I believe it is known by virtue of its documentary title, my lady, the petitioner would be deemed to be in possession of the property unless the petitioner had discontinued his possession or abandoned his land. My lady, he is deemed to be in possession of it by virtue of the documentary title. That has been confirmed in many cases. And then that's repeated over on the right-hand page, having quoted something from Powell and McFarlane. So that's the context in which it's being said we're not claiming possessory title. They're explaining that their submission is that by virtue of the paper title there is a deemed entry into possession. But nevertheless there was a great deal of evidence about possession, all of which would have been completely redundant. I'll come on in a minute to explain what we say the evidence shows, but all of which would have been redundant if in fact it was a stand was being taken simply on the documentary title. Well, can we then look at how it worked out in the Court of Appeal? If we go in volume 10 to tab 254, page 6494, 10254, page 6494. This is the notice of appeal against the judge's order. And if we go to paragraph 5, which is 6497, one of the grounds of appeal was this. In paragraph 5 of the judgment, the learned judge summarised the petitioner's claim by stating that the petitioner relies on the title of its predecessors in title, Avon Bay, and its possession of the said land, together with its own, the petitioner's possession, to establish its root of title in the said land. The learned judge was wrong to accept that the petitioner claimed any title to the property by virtue of a possessory title acquired by its predecessors in title, in that the petitioner only asserted a possessory claim from the year 1988. So at that stage, the complaint being made was actually their claim was only in relation to their possession after 1988, i.e. when they took the conveyance. And one of the other references I wanted to take your lordships to just briefly are in volume 11. (6503), which is behind tab 255. 6503.
Thank you.
This is the appellant's written submissions. And if we go in that to 6515, we see again this expression of what they thought the claim was they were dealing with. There was no claim for possessory title other than the alleged title acquired subsequent to the 1988 conveyance. And then 6526. There's a reference in parenthesis. It's put slightly more obliquely, but if it did claim such a claim, it was subsequent to 1988. Then, my lord, 6544. This is dealing with respondent's alleged claim to a possessory title. The appellant repeats paras 4.3 and 6.3 above and states that the only pleaded claim to a possessory title was the claim in respect of the period subsequent to his purported acquisition of property in the year 1988. For the reasons hereinafter stated in para 6.61 below, the appellant submits that no possessory title could be acquired by the respondent following the filing of the 1995 petition. And what that takes you to is a set of submissions at 6.61, which is on page 6555. Those are submissions about the effect of the 1995 petition, as it was put, stopping time running. So that was the answer that was given to what was thought to be what was going to be coming, which was an attempt to defend title on the basis of possession since 1988. You can't do it because of the effect of the 1995 petition stopping time running. My Lord, your Lordships will remember that you were taken to, I've just mislaid my reference to it, but you were taken to the transcript of the Court of Appeal, where counsel was being asked about what the case was that was being put. And what he says is, I think it's 7807, which sorry, wasn't provided, unfortunately, with volumes myself, so I've had to put it all back together. Volume 12, I'm very grateful. What's that one? Sorry, I'll cross-check.
What page are we going to in volume 12?
7807. Yes, my learned friend's quite right, I think. Thank you for that. Yeah, this is the passage I wanted to go to. This is counsel for the association speaking now. Line 4, in terms of any adverse possession which would give rise to a title under the Limitation Act, I understand my learned friends not to be claiming any possession because they cannot. But if I am to understand otherwise, then I would like an opportunity to reply to that by referring to my submission at 6.61. And Justice Sophia Adderley says, I think we understand they're not claiming that. So, Lord, that was the extent of the reference that was going to be made, but was not in fact made because of the statement that they weren't relying on a possessory title. So, so we can draw, I say, two things from that. One is that the association did prepare its submissions for the Court of Appeal on the basis that it would have to deal with a contention that EPL had title because of possession from 1988. And two, having known that was what was coming, the only submissions it prepared to deal with that was a submission of law about the effect of the 1995 petition. And we say it follows from that protests, which are not made in the written case, but are made in my learned friend's speech on Tuesday, protests about the procedural unfairness of what the Court of Appeal did are not really well taken, because it doesn't demonstrate that there was anything else that would have been said that wasn't said. It's not as if there was a whole stack of submissions about how possession works in the law, or how on the fact possession should be looked at, that would have been taken but weren't taken. It's simply one point of law. And so for those reasons...
The real point is a sort of forensic investigation of the facts point.
I'm sorry, Miller?
The real point might be the absence of a full forensic investigation of the facts. But as I understand it from their notice of appeal, that the disclaimer of a separate possession case after 1988 only arose in closing submissions at the trial. I mean, is that
that's right. There was certainly a full investigation at the trial otherwise there wouldn't have
been an opportunity for full investigation of that as a live claim during the witness part of the trial. The evidence part of the trial.
I think that's right.
Though not necessarily, I suppose, depending on who went first in closing submissions, not necessarily in submissions.
That may be right. Yes, but certainly when we come to the Court of Appeal, I taken, as it were, adopt the implied point behind that, but also in the Court of Appeal, of course, we take the point that they were expecting to deal with a possession claim, and they prepared long and detailed written submissions, but the only point they took in opposition to it was a legal one. And can I then turn, with the time I've got left, to the claim that EPL made and succeeded on, first of all in relation to possessory title. It's a very simple claim in contrast to the rather elaborate scheme that you have to buy into in order to fine for the association. It is simply that EPL, intending to possess the property, dealt with it as an occupying owner might have been expected to deal with it and exercise sufficient exclusive physical control over the property, bearing in mind all the circumstances. My Lord, that was the test that was set out by the Court of Appeal in its judgment. The President's judgment contains a lengthy, I've shown you this already, I think, a lengthy self-direction by reference to Pye and Graham, Powell and McFarlane, Armbruster. There's a review of the evidence concerning possession. There's a reference to what happened in 2009 with the bringing of proceedings to remove Manasseh Mackey from that part of the property. That incidentally, I had understood, was an agreed fact. It's in the Statement of Facts and Issues that, as an agreed fact, that there was a successful, one way or another, there was a successful removal of him from the property in 2009. And that was all, said the President, the basis for a clear case of factual possession and intention to possess to the exclusion of all others. And can I just take your Lordships to it briefly in volume 12 to deal with the point that my friend makes about Ocean Estates and the role, if any, that played in the judgment. My Lord, if we pick it up at para 90 of the judgment, please. Sorry, my Lord, 7411. This is after the judge has already cited at great length Powell and McFarlane and Brown and Faulkner. She then she sets out the evidence and she goes through it and comes to her conclusion that, as I've already said, at 98, this was a clear case on the part of the respondent of factual possession of the property and the intention to possess the same to the exclusion of all others. And of course those two elements are the classic two elements in the Powell and McFarlane test for, and on all the authorities, what the test is for possession. So she's not directing herself there by reference to any lesser test, any test that all you need to do is to show the very slightest acts of possession. She's directing herself squarely in line with the established authorities about adverse possession. And then she says at 99, and this is the foundation upon which my learned friend seeks to build his case, that there's an error of law here which should justify your Lordship's getting involved in the matter. She says the Privy Council decision in Ocean Estates clearly demonstrates that the aforementioned acts were sufficient to establish possession. And she quotes a little passage there from Ocean Estates about the architect's inspection and the surveys establishing sufficient possession to bring an action for trespass to land and negative any intention on their part to abandon possession. Well, my Lord, I think I'd make 2 points about that. The first is that on any reasonable reading of it, that is something of a tailpiece to the judgment, which has already reached a conclusion based upon a square assessment of factual possession and intention to possess and whether the evidence meets that test. If she was intending to direct herself to say that all I need to do to be satisfied that the EPL have established a possessory title is to find they had the slightest acts of possession, then she would have said so. And it would have been a slightly odd thing to say in the context. And the second is that just because in Ocean Estates and Pindar the context was, are these sufficient acts of possession so as to fall within the necessity of that you have to have even as a paper title holder, query. It wasn't even clear in Ocean Estates whether it actually was, that was the law, but they assumed it was the law. Just because that was the question in Ocean Estates, it doesn't invalidate the proposition that it is that it can be an act of possession in the right context for somebody to survey land or to have it inspected by an architect. There are two different points there. Whether it constitutes possession or not, and whether it's a sufficient act of possession are slightly different things. And there's no basis for thinking in my submission that the judge is relying upon, as I say, upon the particular nuance, the particular fact that in Ocean Estates they were looking at whether it was sufficient in that context. But the short point is really it's really an answer to I think the point that my friend makes, which is, well, it's not really enough to survey property, and it's a perfectly good answer to it to say, well, it was considered enough in Ocean Estates. But your lordships will, of course, nevertheless want to look at the evidence that there was for possession and rather not just fall back upon saying that this was a factual decision which the judge was entitled to reach. And in my submission, if one does that, it is pretty clear that EPL's evidence of possession was sufficient in the present context, including in particular the context that there was really no other serious contender for, once you dismiss the association's elaborate scheme, there is really no other serious competing contender for possession. And I put it that way, really picking up a sentence in Armbruster, which I won't go to, but in that case it was said, in the absence of any other serious claim, the board was prepared to find that certain things were acts of possession. So it is relevant in the context. But the starting point is what the property was actually like in 1988. This goes to the factual question of what you would expect an occupying owner to do with the land, because your lordships have been pressed with the idea that this was farmland, and therefore if there was no farming of it, then there was no occupation of it. But it's important in my respectful submission to keep in mind really what sort of land this was. It's true that there was farming of a sort on it at an earlier stage, but it hardly makes it farmland in the way that one might think of that expression. One does need to, in my submission, to set aside any European notions of what farmland consists of. The English countryside in particular, of course, is famously man-made and been tended in one way or another since the Doomsday Book and probably well before that. This is nothing of the sort. This is an outlying island in the Bahamas, which, in my submission, by the time EPL acquired whatever they acquired in 1988, and began doing the things of which we rely upon, which had essentially reverted to almost all of it to bushland. It was just virgin forest and bush. That's the context in which one has to think about, in my submission, what you'd expect someone who owned it to be, who was occupying it, to be doing with it. But my lord, just to pick up the evidential references, and I'll take this as quickly as I can. The starting point is 1974. Hubert Williams, who's the photography chap, he says in a witness statement there are no clearings consistent with farming. If your lordships have volume 2 open, that will pick up most of these references, I think. This is page 938. That's page 12 of his statement. There are no clearings that could be consistent with farming in 1974. But there are a number of roads running east and west from the main road providing access to the beaches on the ocean side of the island. So he says there that there was nothing visible. It's true that he conceded a bit in cross-examination. If your lordship leave bundle 2 out, but take up also bundle 5, volume 5, at page 2343. This is him being cross-examined. You've commented on the question, this is line 17, commented on the question of pothole farming. And you have, I understand, acknowledged that it's very difficult for you to identify that type of farming from photographs of this nature. Yes, so that it really is quite possible that there could be very extensive pothole farming on that property. Yes, separate and apart from the clearings that you identified. Yes. But he qualifies that in quite an important respect at 2411. in re-examination, he's asked you where you could have seen those clearings that could have or would have been pothole farming. Would you have expected to see some access roads that would have led to those? Yes. That would have shown there was farming there? Yes. Did you see any such access roads? No, ma'am.
What page was that? Sorry.
I'm sorry, what?
What page was that?
That's 2411, my lord.
Thank you very much.
Well, that's a very straightforward, common sense point to make, of course. So you would expect that if people were pothole farming, they'd have to get to their pothole farms and back at the end of each period they wanted to go there, and there would be some sort of evidence of them having done that, and there wasn't. So that's 1974. So the likelihood is, therefore, that by 1988 we are dealing essentially with an uncultivated wilderness. And that's important, as I say, in terms of what we then what one needs to think about in terms of occupation of the land. What then happens? Well, Stafford Coakley turns up in 1988. He reopens the boundary strip. This is, we go back to volume 2. This is his statement, page 687. As I reopen the boundary lines around the subject land.
What's that mean?
Well, we say, my lord, it means it doesn't seem anywhere to have been expressly explained to the court what that meant, and one suspects that's because it didn't need to be explained to a Bahamian court what it meant. But we say what it means is cutting back vegetation so as to leave a demarcated strip.
So it said whereabouts, because you've got a road on one side, you've got the sea on the other side.
Yes.
So whereabouts?
Oh, where?
Yeah.
Whereabouts? I think.
And where's the evidence as to whereabouts?
And was there any doubt about where the boundary was, whether it was cleared or not? I mean, on the face of it, a road is a road.
Yes, I think that's right. I think we are. To be fair, I think we are talking about those boundaries which are not demarcated by something else. I.e., the road and the sea are natural boundaries.
But we were told
one's natural, one's man-made.
But the top and bottom.
Yes, I think that's essentially right.
So if there were stone walls at the top and bottom, what was he doing? Just cutting the vegetation off the walls?
Well, there was it's not quite. I misheard your lordship when I didn't hear you said it was stone walls at top and bottom. I think it's the stone wall along the bottom. There are parts of the boundary which are described as guinea grass. But as I understand what's meant by this is even in respect of the stone wall area, it's cutting vegetation back.
Yes.
From by the wall.
I understood from Mr. Jordan's opening submissions that there were indeed stone walls along the top and the bottom of the Gift 2 land.
Well, no, he may well be right about that. But the important point for our purposes is that it does leave, we submit, and I appreciate this is not specifically in evidence, but as I say, that's probably because it didn't need really to be explained to a Bahamian judge. This does leave something where it becomes apparent that this is a boundary between two different plots of land. And that's, in the context that we're dealing with, that's important, of course, because we would say it's akin to putting up a fence. We're criticised. It's said that if we wanted to establish clearly that EPL owned the property, they should have put a fence up round it. Well, it's 3 1/8 square miles of land. And Lord, having failed to add 21 to 39 correctly yesterday, I'm not going to attempt the necessary use of pi and so forth to work out what that would mean for the circumference of the land. But it's quite a lot. It's quite a long circumference. It's in context. I say it's a significant thing for EPL to have done, to have left. We say something which is a reopened boundary, which, as I say, we say does leave a demarcated boundary strip.
And there are no costings for that.
There are no costings.
No costings. It doesn't tell you how long they took, or there are no photographs of it. There's no costings in relation to how much they had to pay?
I don't believe there's any evidence of costings as to how much they had to pay. No, I mean the evidence was, of course, that they'd essentially retained a series of people to work for the company, acting as the surveyor, and they'd taken it in turns over the years between them. They'd done this business of clearing the boundary lines several times.
Is his survey report in the bundle? One would have thought that that would answer some of these questions.
Is it?
I think your opponents are saying no.
Is it one man with a slash hook, or is it one man with a bit of equipment, or?
I don't think that it was gone into in evidence, my lord, is the answer to that.
The case against you is that really using this land involves growing things on it, or cutting off bark, or crabbing and so on.
Yes.
And really what you're pointing to is none of that. I mean, in Ocean Estates, they were planting the fruit trees and harvesting them.
Yes.
Using the land for its appropriate purpose.
Yes. Well, my lord, the answer to that submission, I'd say, comes back to my point about the fallacy of regarding this as farmland. It's not. This had been land upon which people had done a species of farming many years earlier. But that was in the distant past, and certainly so far as the great majority of the land was concerned, there may have been the odd pocket here or there where it was different, but certainly as far as the great majority of the land was concerned, it had been abandoned for that purpose, and it had reverted to an area where there was not that sort of activity going on. It had gone back, as I say, to being effectively virgin bush, virgin country. And in that context, if one then accepts that it's not, as it were, farmland, so you can't say, well, this is a farm, so you should be farming on it if you're going to occupy it. One of its other obvious possibilities is development land.
Yes, because in the absence of development, the appropriate use is farming or nothing.
Not necessarily, my lords. I think I'd make 2 points about that. One, I'm not sure I accept it's right, and two, it certainly isn't a proposition of law.
No.
It's a proposition of, this is all a question of fact as to whether one is doing what one expects an occupying owner to do. And if one is proposing to develop land but has not yet developed it, then what you'd expect to do with the land is to mark it out in some way, to keep an eye on it, to survey it, to put signs up, which they did, saying this is our land. That is the use of the land that would be expected. If your lordships were to accede to the suggestion that you should lay down some sort of rule that says that you have to fence off your land, otherwise you might lose it, if you're proposing to use it for development but not yet, and it's the sort of land where there are other things in the past that were done on it, then that would be no doubt seized upon in other cases by people who would say, well, this is a clear case where there's no possession made out.
Well, it's not only a question of what would be a normal use of the land. One possibility is that acts of possession were performed by both the people who were farming the land and your clients. So what happens then? Does one have to work out, the nature of the act required by your clients to assert possession may well depend on who is on the land as it is.
Yes.
If you put a notice saying this is our land, keep off, at the borders of the land, and it is being actively farmed by other people, that may not be good enough. If it's apparently empty, then it may be.
Yes.
You would accept that?
I think I'd accept that as a general proposition, my lord. Yes, which is that's why our submissions go through not only the evidence of what we did, but also the evidence of what my clients did, but what could be seen on the land at the time.
Well, except that the evidence is also that the courts below concentrated on this question of whether the people who were farming the land, potholing the land, were occupying it on behalf of the whole class. But it appears pretty clear from the evidence that even if they weren't, there were people there who were in possession of, at any rate, some parts of the land, maybe not all of it, and that is a factor that
Yes.
may undermine the impact that would otherwise have to be given to putting up notices.
Well, one needs to be very clear about when this is happening. The evidence that was given about the joint intention was almost to a man, Charles Roll, I think, being the exception, by people who had themselves, who were not contending themselves to be still, at any rate, other than very sporadically, in any sort of occupation of the land. The case that's put against us is...
Charles Roll, is it? Because Charles Roll's own evidence was that there were other people farming.
Well, he says there were two others. Yes, I took
Yes.
that.
But also your own evidence, I seem to recall, records conversations with people who appeared to be on the land and farming.
Yes, I accept that, Lord.
Says to them,
It's a question...
you know it's owned by EPL, and they say yes, and everybody smiles at each other and
Yeah.
goes their separate ways.
Well, look, it's why it's important to keep everything quite distinct. There certainly was a period many years ago when the land was very actively being farmed. There was robust farming, as it's put in the evidence somewhere.
We're talking about the 60s.
But that's right. But that and the focus there on was indeed quite rightly on whether it could somehow be said that at that stage there had been this joint possession, etc., which your lordships have heard probably far too much about already. But in terms of EPL's claim to possession, we're talking about the period from 1988 onwards, when, as I've sought to demonstrate, in general terms, the land has reverted to bush. And in that context, I come back to a point I've made a couple of times before, which is important in this context. We're not concerned with a claim by one individual who says, I know you claim this 2,000 acres, but I've been on this patch of half an acre in the corner of it, and as regards that patch of half an acre, I claim that I'm in adverse possession of that, I'm in possession, not you. We are concerned with a contention that that there has still the occupation of the whole of it by people from whom the association derive their title. Those are the only two competing alternatives that are being presented in terms of the possessory claim.
In order to establish a possessory title, have to establish single possession.
They would have to have, yes, they would have to establish, as a matter of law, single possession. But as a matter of fact, what does that constitute? Our submission would be, even if it's accepted that there are, and it may well be accepted that there are sporadic incursions upon the land by other people, that has to be looked at in the context. It can't be said that simply in practical. It can't be said if you've got a case. Imagine a case where it's clearly understood that a certain plot of land is occupied by a developer who is about to use it for certain purposes. The fact that some people encroach upon it from time to time, and sometimes they might kick them off, and sometimes they might be a bit tardy in kicking them off, whatever it might be. That doesn't mean one can derive from that the proposition that they're not occupying the land.
When you describe it as incursions, you are assuming that there were sufficient acts of possession of empty land, which was then invaded by other people, believing themselves to be descendants or whatever. The problem is that there is evidence that there were people on the land somewhere. The putting up of notices or the clearing of boundaries or flying over the land would surely not be a sufficient act of possession to, so to speak, evict those who were already there. That would suggest that there was a form of possession of some parts of the land by some of the descendants. Now, it may well be that that would not be good enough for the association because of the concurrent findings that they weren't occupying the land on behalf of the class, but only for themselves. But the net effect of that is that it may be that neither the association claiming on that basis nor your clients have got a possessory title, and there may, however, be a possessory title on the part of certain of the individuals, but that's not the claim that we are currently hearing. If that is the correct analysis, the answer would be that there would be no certificate, and in some subject to the point which I asked for your assistance on at 10:30, it would be open to any of the people who are barred from bringing claims in these proceedings to bring subsequent ones asserting that they had title on a rather more modest basis than either of you.
Well, my Lord, I think the answer I give to that is that the fallacy in that argument I would submit is to regard the possibility of these other small claims in relation to specific bits of the property as defeating the claim of EPL to being in possession of the whole, because they don't. Those individuals do not assert that they are possessing those particular bits of land on their own account. Certainly, on the only case which is before the court is a case by the association saying, on behalf of its members, this was whole possession of the whole thing, and EPL's claim.
Yes, I mean, the result of the hypothetical analysis I put before you for consideration a moment ago is that both parties fail. Because, essentially, because the acts of possession, let us suppose that there's no documentary title. It's common ground that there's no documentary title in the people who conveyed their interests to the association. Let us suppose that you don't have a documentary title either. Now, I beg that question at the moment, and we're only concerned with possessory title. We have competing acts of possession. Your acts of possession being arguably insufficient to evict those who are already on part of the land, their act of possession being insufficient to confer on the association title over the whole. That means both of you fail, and it's a free-for-all in any subsequent proceeding.
The answer, my Lord, is that there aren't, even on that analysis, we would say, competing acts of possession, because the evidence putting it at its as it were worst against EPL, the evidence is of individuals who do not say we inhabit the land at all. Of course, everyone agrees that. They don't even say we farm a specific bit of the land, and because we regard that bit of the land as our bit. On their own case,
they say they roam about.
They say they roam about. So hence my use of the word incursions. It is more a case of incursions. I could see that if there was somebody who had been on the land, either living there or it was an established thing that they went to for year after year after year, or day after day, but sleeping somewhere else, for example, I could see one might say, well, that's possession of that bit of it, and therefore that is.
Well, they are shifting acts of possession, and the problem is we just don't have enough information. But it wouldn't be relevant anyway, because nobody is claiming. What we have is two claims to the lot.
Yes.
And it may be that somebody has a claim to a bit based on possession, but that's not a claim that's before us.
Well, I agree, but the answer to that, in my submission, is that the process under the Quieting Titles Act requires that notice is given. Anybody who wishes to make a claim is entitled to make a claim. Yes. And so that there should be no concern for the interests of any persons who might have a claim that didn't make it because they've opted not to make it.
To one of two people, neither of whom can make out a claim, simply because they're the only people before the court.
No, of course I accept that, my Lord. If perhaps I should have taken it as read that any such reasoning doesn't come into it. But the difficulty, the fallacy in the argument in my submission is in regarding the evidence of there being other people who sporadically did certain things on the land as negating intention to occupy as a occupier would be expected to occupy in all the circumstances.
But on the part of it's actual occupation, isn't it?
It's actual.
Yes, I'm sorry, I'm probably paraphrasing it wrongly, but as negating what needs to be proved here, which is actual occupation with intention to occupy.
But it affects the character of the land, doesn't it? We know that Mr. Forbes, Mr. Martin and Mr. James Wilson were farming. We know that for a time Mr. Mackey was there with a tractor clearing the land. This is not simply an uncultivated wilderness where all you can do is mark the boundaries. These are individuals who are roaming around farming different bits of it. And therefore it makes it more difficult to say that this is simply simply a wild development site that you can only fence.
Well, one needs to focus on what the evidence shows at each time in relation to this, because the 2000, can I take your lordship first of all to the position in 2000? That was made the subject of a photograph, which I can take your lordships first of all to the evidence about it, and then if I may show your lordships the photograph itself. That is in volume 5 at 2441.
And I apologise for taking you out of your course so shortly before the expiry of your time, but I did want you to aim at the right target.
I'm always grateful to be guided towards the right target, my lord, so I don't complain about that at all. My lord, 2441. Thinking about questions of time, my lord, I think your lordships we started at 22 rather than 1/2 past. So
you're entitled.
May we share the 10 minutes between us?
I think you're entitled to continue until you're suggesting 12:05.
If that would be all right.
Done.
I wanted to go to 2441 just to explain that this is the photograph saying we wanted to see possibly what could be growing in the underbrush. So he flew at 2,000 feet to get a scale of 1 in 400 feet. Mm-hmm. And the point about that is it's a photograph designed to ensure that we can see what's in the underbrush. And then may I just pass up
when was this?
That was the 2000 photograph. I may just pass up copies of those, my lord.
Okay. Right, this is a document we haven't already got, is that right?
That's right, yes. The
No,
court below
there's no objection to that.
I don't assume there's no objection to it. It was... Have you not got a copy? No.
Would you want to have a look at it before we do?
No, I'd just like a copy.
Okay, that's fine, in that case.
Compare it to the one I've got, which is...
That was the photograph that was put in support of the proposition that in 2000 there was no clearing on the property apart from the remnants of 2 areas that had formerly been farmed. We then have, and I'll just leave that for your lordships to look at it, I can mean at other moment, rather than take up more of my time on it. But we then have the evidence that from 1994 to 2004 the boundaries were reopened twice a year, and there were signs being put. This is all in our case, so I won't go to it now, I'm out of time. This is Mr. Patron, that's right. Putting up signs. They stayed up until 1996 or 1997 when they started getting removed. Mr. Fernanda clears the boundaries from 2005 onwards, which he does annually. He also puts up signs. And then I do need to deal with, in 2006, with the point about the cultivation that was apparent there. And the point I make about that, and I've set out the figures in the written case, but the plan which shows these areas the plan is in volume 2, page 680. The plan looked at on its own might be apt to mislead a bit, I suppose, because one might, looking at it, think, well, gosh, it's all over the land, this cultivation. But actually, if one looks at the key to it, one can see that there is a narrative which sets out the area involved. And it's a very small area.
Volume 2, page.
Volume 2, page 680. This is only a very brief, fairly short period before the claim is commenced. This is the plan that's prepared, I think, in there's a date on it, 2000 and, I should know. Yes, it is 2009. I thought that was right. I want to check it was right.
2009, right?
2009. So right at the end of the period. And if one totals up the area, I've done the figures in the case, but it's 12.28 acres. So it's 0.59% of the total area that we're concerned with. And I also make the point, we do this in the case as well, that although the buildings are described as under construction, that's actually rather misleading if one looks at the evidence itself. They weren't under construction. They had been under construction at some previous point, but they were no longer under construction. One of them, the evidence was, and again the references are in our case, but it's 2542 and 2545. One had come to a stop, just a foundation, and the other one was up to belt course, which I think means the windowsills. It had trees growing out of it, so it was something that had been done at some point in the past. And then in 2009, of course, you had the going to court to remove Manasseh Mackey. My Lord, our respectful submission in relation to all of that, Your Lordship will have anticipated from the response I've given to the questions. I accept that there is therefore some evidence of some people on the land, but I do rely upon on the point that the contest is between possession on the part of EPL and not possession on the part of EPL, and in circumstances where no one is asserting, other than through this elaborate joint theory, that he or she was in possession in the legal sense of any particular part of it. I do also respectfully submit that the President had the right test in mind, and she reached a conclusion, which Your Lordship's, with respect, quite right to subject to some fairly severe scrutiny, but which was, in my respectful submission, a tenable one for her to have reached. And she did refer in some detail to the evidence that I've gone through, admittedly fairly briefly, in the circumstances, and reached that conclusion on it. And in my submission, that was a perfectly tenable conclusion for the court to reach, and indeed we submit the right one. My Lord, I deal very shortly, I think I'll deal by reference to my case, if I may, with the points about the limitation period and the effect of the 1995 petition. The limitation period, very briefly, there's a completely new case, I think, which is now put, which is that you have to look at the proviso to section 16(1) of the Limitation Act. My Lord, the short answer to that is that section 16(1) has a proviso, which is a proviso for section 16(1), and is not a proviso to section 16(3) that we're concerned with.
Why doesn't it say subsection?
My Lord, I don't know why it doesn't say subsection, but it clearly should, and it clearly is intended to refer to that. May I just ask Your Lordship to turn it up? It's Authorities, Volume 1, manuscript 8, memory stick rather, 8169. The relevant page is page 8181. The bit of background that one needs to know to make sense of this is that the limitation period for actions by the Crown had previously been 60 years. And so the two provisos to 16.1 both make sense in that context. Having reduced the period from 60 to 30, the first proviso, which is typographically only a proviso to 16.1, because that's where it's put, is one which reduces which says that it continues and expires at the time when it would have expired. And the second proviso says in any event it's not more than 30 years from the date of the Act. So that if the 60-year period had started ticking the day before the Act came into force, then it expires after 30 years, not after 59 years, as the first proviso would have said, if that makes sense. We're concerned with subsection 3, no action to be brought after 12 years. And that has a different proviso, which has nothing to do with the proviso that's relied upon by the association. So far as the point about the effect of the 1995 petition is concerned, we rely upon what the Court of Appeal in England and Wales said in Markfield Investments and Evans. That's at 141 of our case. With regard to any particular action at the relevant time, said the then Lord Justice Simon Brown, any particular action, the relevant time and only relevant time for consideration of adverse possession is that which has expired before such action is brought. So that isn't an answer in my submission. Finally, my Lord, and the few moments I've got left, the documentary title, what's our answer on that point? We, broadly speaking, agree, and I'm addressing also your Lordship's question yesterday, we broadly speaking agree with the note that my learned friends have put in with certain qualifications. The first is that the scheme of the Act is not such that one can simply turn up and object to a petition. One has to get through a gateway of being oneself a claimant for a title, an adverse claimant. That's Section 7. And we say it follows from that the basis for your objection has to be one which undermines the petitioner's claim.
It's not good enough for a party to simply challenge the adverse party's title on the basis that it belongs to a third party.
Yes, precisely. My Lord, how do we defend the judge? And the other qualification to the note I would add is that they my learned friends, say, of course, if you've been in actual undisturbed possession of the land for 30 plus years, then it would be wrong to allow investigation of what might be a historical defect. We say the figure should be 12 years, and logically, if adverse possession is what cures it, then it should be the period for adverse possession that cures it. But that's essentially another way of saying if you get home on a possessory title, then you get home on a possessory title anyway. But how do we defend the judge's decision in the present case? Well, my Lord, very briefly, if one goes to the...
If there's no documentary title, does the question of adverse possession arise? Because there's nobody to whom the possession would be adverse.
Maybe the adverse is it's a question of possession, yes. Yeah. And I did want to mention in that context, incidentally, the question of the applicable limitation period. I've skipped over that in my haste, but I shouldn't have done, because we say in our written case that actually limitation, once one rejects the association's claim to possession, then on the face of it, limitation doesn't come into it, because it's trite law, of course, that possession gives title. So once you're in possession...
It gives prima facie title liable to be defeated by somebody showing a superior title. But that
yes, but in the absence of anybody showing a superior title, it is an estate in land. Yes. It is title. And somewhere in the material, I think in grey, it talks about this.
Familiar.
It's all very familiar stuff.
But the adverse possessor can't bring possession, but proceedings to establish title until the end of the limitation period.
Not in England and Wales, no, because the statutory scheme says now, under the 2002 Land Registration Act, there needs to be 10 years.
But if there is no documentary title, then adverse possession doesn't arise. It's simply a question of possession.
Yes.
Whoever was in possession had a good title against anybody other than somebody who had a documentary title. On this hypothesis, there was no such person. So it's simply a question of who prevails as between rival purported acts of possession.
My Lord, that's right. That's right. The qualification, of course, my friend says, well, if you look at the scheme of the Quieting Titles Act, it seems to envisage that that in order to get home on it, you have to show possession for the limitation period.
Well, if there's a documentary title, that's deemed to be the case. If not, then it's got to be actual possession.
Yes, that's right. But the way I would put it is to say we say on the evidence that possession was established for the limitation period of which is 12 years, for the reasons we've given. But that in fact, even if we're wrong about that there was, on any view, we had the better claim to be in possession of the land, even if it hadn't been 12 years, and that would have been sufficient to establish an estate in land in the absence of any other person claiming, because the Quieting Titles Act, although I accept that it seems to be drafted on the basis that you will need to show 12 years, it doesn't say in terms 12 years it has to be, or else. My Lord, I think that's more or less my time up. I was going, if I had had time, to deal very shortly with my point about the judge's judgment. The answer is, if I can do it, perhaps allowing a sort of few moments of injury time for the questions that Your Lordship put at me.
A few moments.
Literally a few moments. The answer is that if one looks at the Conveyancing and Law of Property Act, the provisions which are incorporated by reference there create essentially a scheme of presumptions, so that it is correct to say that a document which is 20 years old has a different status from one which is not 20 years old. Mm-hmm. It doesn't become conclusive, but it becomes presumptively a document which states the truth. That's the effect of...
That's 30 years.
That's...
For that purpose, we're talking...
Yes, we're talking about the...
20.
Yes, you're right. So to that extent it does. And the scheme of the Act, therefore, is that what is said in a recital is presumed to be true if it's old enough, unless otherwise established. In the present case...
Unless otherwise established.
Yes. Unless the court... Yes. Unless the court otherwise orders, I think is the wording, but it comes to the same thing.
Effectively, the court has otherwise directed in this case, because it's entertained the possibility that the 1959 conveyance might not be...
It has, but if one considers its possibilities through, bearing in mind that Arthur Vining Davis recited in his conveyance that he was the owner in fee simple, mm-hmm. The question is then, well, what is there sufficient to displace that? And what we do have here is that it's not a straightforward case where it's obvious that he had no interest in the land whatsoever. He had a number of conveyances to him, 133 of which came from people who themselves recited that they had been in occupation of a portion of the land for very long periods of time. They had, we would submit, something to convey, and at least one of the possibilities is that actually what happened, hypothetically, is that between them they conveyed all of the land. An alternative possibility is, of course, at the other end of the spectrum they conveyed nothing at all, but we simply don't know. And bearing in mind the way the presumption works, the court was entitled to say, while it may have been wrong to say, I accept on reflection that it was a good route of title in the conveyancing sense, it was entitled to say, under the context of the Quieting Titles Act, that it was a sufficiently well-established documentary title. My Lord, those are the points I seek to make. If there's anything further that I'm burning to say, I will seek Your Lordship's indulgence to say it in writing.
Thank you.
Lord, I've made some notes because there's a lot of material to get through, and I hope it's not impertinent to hand those up and to ask the board, if I don't have time to address everything in them,
to read the rest of it.
Most grateful. While that's being handed up, Lord, may I just address the question raised by my Lord Sumption at the start of this morning about the effect of barring. In our case, we set out in some detail, and I hope it wasn't tedious, how the old system of investigating title after contract worked, because it's pretty unfamiliar these days. Certainly, since I started as an article clerk in 1985, it was unheard of for anything like that to ever be done. In this country, it's a completely obsolete system where you exchange contracts and then investigate title. It's always done before contract. But under the old system, which is reflected in the Conveyancing and Law of Property Act and in the Quieting Titles Act, you exchange contracts first, and then you find out whether the person you've exchanged contract with has any title. And they have to produce an abstract, and then you raise requisitions on the title, and if the requisitions are objected to, then you go to the court on a vendor and purchaser summons to get it sorted out. And in that context, even a cloud on the title which could give rise to the possibility of litigation, is enough to raise a proper requisition. And one needs to understand the Quieting Titles Act in the context of that practice, of that way of dealing with sales of land, because the starting point under the Quieting Titles Act is the court is effectively in the position of the purchaser under an open contract, investigating the seller's title. That's why the Conveyancing Law of Property Act is incorporated. And if somebody says, well, I have a tenancy, or there's a restrictive covenant, or I'm the real owner, or something, instead of it being dealt with on the basis of, well, there's a cloud on the title, so the purchaser can pull out, the court investigates the position and makes a determination. And if somebody doesn't put in an adverse claim, they are barred. But the barring is not intended to prevent the court from properly investigating the title and giving it thorough scrutiny. And because the effect of a certificate of title under the Act is so extensive, it's more extensive than registration of title is here, because the register of title can be altered if there's a mistake and there's a scheme of compensation. If the registered proprietor hasn't contributed to the mistake by lack of proper care or fraud, he gets compensation. But the register of title can be altered. But once a certificate of title has been issued, unless it can be proved that it was obtained fraudulently, it's absolute, and it bars the title of the true owner, which could never happen with a contract for sale. If a purchaser is foolish enough to enter into a contract with somebody who's selling something which patently they're not in control of, they're not in actual possession of, and ends up finding that the title is forced on them, well, that's their problem. It doesn't affect the person who actually owns the property. It doesn't affect anybody who's got an easement or a restrictive covenant over the property. The effect is purely contractual between the seller and the buyer. But the effect of a certificate of title is in rem. It binds the world. It actually gives a 100% guaranteed title to the person who gets a certificate of title. And so one must, in my submission, interpret the Act in the light of that. And step one, the court must be satisfied that there is a good title. If that's the case, and if a certificate of title is issued, then that bars the claim of everybody else.
But in theory, there's no problem about a cloud on the title, because everybody with an adverse claim is either barred or there.
Yes.
So that the court isn't confronted with the sort of problem that faces the court on a vendor and purchaser summons, or used to, of having to say, well, we're not going to give you specific performance because there may be a good adverse claim. Here, everybody except those who are there are barred, and the court can deal with claims of those who are there.
Yes. But it's very important that the court does make sure that the title is good. And if the court, at any stage of the proceedings, forms the view that there might be a third party who has or might have a claim, then they can direct a notices served on them. And one of the cases in the bundle, the court was pressed with the argument that because newspaper notices had been placed, it wasn't possible at a late stage in the proceedings to direct that notices were served. And the court quite rightly rejected that argument, said, no, you can direct the service of notices at any stage, because the court needs to be sure that anybody who might have a claim has a chance of putting it forward. So the barring only operates, in my submission, if a certificate of title is issued. That's at the point at which the barring operates. If the petition is dismissed or abandoned, there is no barring. I'm sorry, it's rather a long answer to the question, but that is why I say that barring only operates if an actual certificate of title is issued. Lord, may I just pick up a few points?
If and until.
Yes.
And so that by the end of the proceedings there either will or won't be a certificate. If there is a certificate, the barring is effectively permanent, subject to fraud. If there isn't, you say it ceases to have effect. Yeah.
Well, if I can just pick up some points that were made this morning. Non-charitable purpose trust. With great respect to my learned friend, he is mixing up three different things. There are three different principles that can apply in this sort of case. One is the beneficiary principle, a trust which is purely for purposes and doesn't have any individual beneficiaries who have an interest in enforcing it, and isn't charitable, is void.
Or isn't for the maintenance of graves, I think.
Very much.
Or isn't for the maintenance of graves.
Yes, yes. I think there are one or two Homer-nodded exceptions of that kind, but subject to looking after specific animals and looking after monuments, then yes, non-charitable purpose trusts are generally void. And the reason is the one that my learned friend gave, is that with a charitable trust, the Attorney General can enforce the trust. And with a trust for the benefit of individuals, the individuals who are to be benefited can enforce it. But if it's simply for a purpose, then there's nobody who can enforce it. That clearly doesn't apply here. The property was conveyed to the association to hold for the benefit of descendants, who are individuals. So we can forget about that problem. The second is the perpetuity rule, which, until it was abolished by statute, prohibited a gift which could not then be disposed of for a period exceeding the limitation period. But we can forget about that as well, because it's been abolished by statute prior to the conveyances to the association on which we rely. And the third is the certainty rule. The trust must be conceptually certain. But in Re Barden, the Court of Appeal said a trust for relatives, even if relatives meant lineal descendants of a common ancestor, was conceptually certain, and evidential uncertainty is irrelevant. So, Lord, none of the three factors that can affect conveyance have any operation here. My learned friend, by focusing on the rules of the association and saying, well, they render the property incapable of being distributed to the beneficiaries, ignores the fact that the association is obliged to deal with this property for the benefit of the descendants, and they can come to court and enforce it. So it doesn't fall foul of the beneficiary rule. And in any event, as the board has pointed out, the rules of the association could always be changed. In fact, the rules in Re-Reacher said that if the Anti-Vivisection League was wound up, its property had to be given to another charity with similar aims, but another body with similar aims. Well, in terms of the evidence of Mr. Hubert Williams, we have included in Appendix 9 of our case at page 7990 a number of extracts from his evidence in which he rode back very considerably from his witness statement in relation to what you could actually deduce from the aerial photographs and what he had in fact deduced from them. And I would invite the board to consider that. If I could also ask the board to look in our case at page 7964. Also on the limitations of aerial photographs. This is Appendix 7 to our case, where we have set out extracts from the transcript. Mm-hmm. And this particular extract is from the evidence given by Princess Miller. And if the board could please look about 10 lines up, where the court, sorry, Miss Wilson, she's saying there is one farm he has that extends the witness. No, he has several farms, not one farm, several farms. Miss Wilson, several farms on this property, you're saying, on both sides, this way and that way. How far from the main highway? Well, at first they used to be by the road, but people start stealing. So you have to go a little further in the bush, so you don't see a track road. You would ramble through and then cut the field. So you don't see them from the road, no. So the mere fact you don't see a track road doesn't mean that people aren't going to the bush and carrying out cultivation operations. And page 7970. Another witness, this is Eleanor Roll, said the same thing. This is the second box on the page, about a third of the way down. Question, things were hard, but you never went back on that land to farm? How you mean we never went back on the land? I tell you, most of the over people died, I said, and few of the people who were there, yes, they farmed on the land. They could go anywhere they wanted to because they knew that land belonged to them. They didn't have to say, well, to be a specific area. They go wherever they wanted to. And that's what I know that people did. They had farm in different areas on the south side, the north side, and the west side, and the east side. They had farm all over. I know one man specifically, Mr. Henry Miller, that same man what council asked me about, Henry Miller. He had farm. You wouldn't know his farm was there because people used to steal. He would just cut a little track. You can't see it unless you go in the bush for crab. And you would see this track. And then, when you get there, a big field there. So again, just because you don't see it see a track road when you're going along the main highway or along the Guinea grass road at the top doesn't mean that people aren't going into the bush and clearing an area and cultivating it. They don't leave a track road because then people will follow it and steal their produce. Lord, the evidence was that Charles Roll and Cecil Williams at least continued using the land. Charles Roll right the way up to the trial. Cecil Williams, he said, had stopped a few years earlier. Hubert Forbes and Jimmy Wilson were noted by Ricardo Fernanda as using the land. Other people used the land for a variety of purposes, crabbing and so on. It certainly is not the case that it had been abandoned. It wasn't just an abandoned piece of wasteland, which is almost the picture that my learned friend was seeking to portray. It is fair to say that it wasn't being extensively cultivated in the period from 1988 on. And I couldn't possibly say that the extent of factual user in that period was sufficient to amount to factual possession, but it was certainly more than enough to prevent the abandonment of possession if it had already been acquired.
But in relation to Charles Raleigh, we were taking some evidence where he said he wasn't farming anymore. I thought Mr. Roche took us to a piece of Charles Raleigh's evidence where he said that he wasn't farming. Unless I'm...
It certainly wasn't his evidence. My learned friend quoted a passage in his evidence where he said he was still farming and had been up there recently to get some banana leaves.
Yes, I'm mistaken, right.
Yes, I think that's right. No,
Yes.
Yeah.
There was a little piece of evidence, and perhaps it doesn't really matter very much. I've dealt with this in the written document I've handed up, but what Charles Roll actually said is that when he was a teenager, he started farming on the land. I think he said when he was about 13. And then he said between the ages of 17 and 21, he was working in the US for sort of 6 to 9 months at a period. And then he came back when he was 21 and started farming on the land again. But whether that makes any difference, perhaps it doesn't. That's what he actually said. So my own friend's both right and wrong in saying that he started farming.
I was thinking of the passage where he referred to other people who were farming.
Other people?
Where he referred to Hubert and someone or other.
Yes.
But let me hold you up.
Lord, we have on page 7974 and following extracted those parts from the transcript of his evidence that we submitted. But if one looks on page 7982 at the top, he says, when you stopped farming on this, you said, I never stopped going down there. I still have a little farm about through on that property. Then he talks about Cecil Williams. The aerial photograph that the court was shown, well, I'm sure the court is familiar with looking at aerial photographs of land. These days one can see them on Google and also on Bing, and this is a pretty terrible photograph. It doesn't show a number of features that were referred to in the evidence. You can't actually see the rock wall, which the witnesses said existed. You can't see a tamarind tree, which was referred to repeatedly in the evidence. When witnesses want to explain where something was, they would usually do it by reference to the big tamarind tree. Just one reference for your lordship's note, page 2658. Mr. Fernanda said the tamarind tree was bigger than this room, bigger than the courtroom. You can't see that on this aerial photograph. One can, in fact, see on the parts of the photograph that are a little clearer than others, in the top left-hand corner by the big pond, in the top left-hand corner, the northern part of the northern bowls land, you can actually see quite a lot of what looks like, to my eye, like farmland, marked out fields, and also to the east of that, just on the eastern side of the highway, there is what to my eye looks like a cleared piece of land. My main submission about this is it's just a terrible photograph. So, Lord, if I can then go back to the written notes that I prepared. And
I just, before my friend leaves that subject. If the complaint about what your lordships have, which was really intended as a piece of assistance rather than to make any particular point, but if his complaint is that it's not a good photograph, it may be to do with the fact that's a reduction from a much bigger document, which is the one that was available in court and which we have available if anybody wants to see it. So I would propose to make it available in case any of your lordships at any point in considering the evidence want to have a look at the version that the trial judge had the benefit of.
So I didn't know that. I thought that what I'd been given was all there was.
Well, it's rather unsatisfactory.
My fault for not communicating that fact properly, my lord. I'm sorry.
Well, whatever be the true position, it's a bit difficult for us to make findings on the basis of our untutored assessment of photographs which are not the subject of any finding by the trial judge.
Lord, if I can go then to my, my note and try and pick up some points from that. In answer to my Lord Sir Rupert Jackson's question about the individuals referred to in Augusta Young affidavit and who executed or purportedly executed, there is a list in the record at page 7256, and there were 17 of them. Paragraph 2, I think I needn't spend time on, since it doesn't seem to be in dispute. Paragraphs 3 and 4 are to do with misdirection. There's the point that my Lord Briggs made, which I adopt, that the judge started from the wrong point. Paragraph 47 of her judgment, in saying that the association had accepted, but it had the burden of establishing the petitioner as the holder of paper title, had discontinued or abandoned possession. In paragraph 4, I do now make a submission in relation to Brown and Faulkner. I've had a chance to read the majority judgment. The way that Mr. Justice Higgins approached it was to take a very sceptical approach to the question of whether Sir James Faulkner and his brother, Lord Brian Faulkner, had jointly possessed the disputed land. He said there was no evidence of an agreement or an arrangement, and two disparate families couldn't constitute a legal entity capable of exercising joint possession. And now that one has seen the majority judgment, that's plainly just wrong. What the trial judge did in that case, and what the majority agreed with, was to infer from the fact of joint user by two members of the family, or several members of the family, that the family was, the two brothers were jointly in possession. That is the right approach. The court shouldn't be sceptical or find it difficult to infer joint possession when the evidence supports that. The next section is headed Rejecting Unchallenged Evidence. And just to emphasize a point that my learned friend accepts that the mass of evidence given by a number of individual separate witnesses, each with their own stories to tell, that they had understood and their families had understood that they were using the land in their capacity as descendants of the named persons in Anne Miller's will, that none of that was challenged in cross-examination. And we all know that as a general principle, it would only be right to reject unchallenged evidence if it was inherently incredible. It was evidence that nobody could accept. But that is not the case here. It's a very likely story, not an unlikely story. And especially in the Bahamas, where there is this concept of generation property, and which, contrary to the suggestion that my learned friend made, is not a concept that is understood to relate only to the descendants of one named individual.
Well, the judge did, I think, regard it as inherently of no value because she considered that it was a recent invention. I know you challenged that, but that was the view that she took.
Lord, that wasn't put to a single witness. Not one witness was asked, well, this idea that you intended to possess in the capacity as descendants, you just made that up recently. You developed that idea recently. Nobody was given an opportunity to comment on that suggestion. It's extremely unfair to then turn around in judgment and say, well, they made this up recently because they knew they couldn't succeed unless they did. The next heading is failing to take into account material evidence. And clearly, if a judge does take into account the relevant evidence and carries out a balancing exercise, an appeal court will not interfere unless the decision is one that no reasonable judge could have arrived at. But that only applies if a proper balancing exercise has been done. And if only the evidence on one side has been put into the scales and not the evidence on the other side, then an appeal court ought to set the assessment aside. So unless the court considers that the Gazette and the pre-1959 conveyances are no evidence at all to support the witnesses in saying that they had understood that they were using this land as the heirs of Van Miller, then the judge erred in law in failing to take them into account. As far as the conveyances are concerned, the key point is they didn't say, I'm in occupation of this bit of land, I'm in occupation of that bit of land. Arthur Vining Davis's conveyancer didn't prepare conveyances relating to different pieces of land and try and find out which bit different people were occupying. Each of the conveyances conveyed an undivided interest in the whole of the 1,700 acres on the basis it was held and enjoyed by them as tenants in common with others. Well, the next heading is treating as determinative the mere fact of adverse claims, whether or not valid as a basis for rejecting the unchallenged evidence. We said it can't have been right to treat it as determinative. At most, it was something to go into the balancing exercise, but the judge treated it as the end of the story. The fact that there had been adverse claims by different adverse claimants, she regarded as just conclusive proof that the whole idea of these individuals who believed they were occupying the land as descendants must have been a recent invention, a recent vintage. The TMCL petition was the first matter to consider. It was based, as the board has seen, on an assertion that the whole of the Gift 2 land had been used in common by a group of 31 people. And they weren't all McKinneys. They included Charles Roll, they included Mitchell McPhee. And they said the land had been farmed in common by them for many, many years, many decades. And we say there are really only three possibilities here. The first is that the claim was correct. In that case, those persons acquired title to the land and they conveyed their title to TMCL, and TMCL conveyed its title to the association, and the association has that title. The second is that the claim was correct in saying that a number of individuals had farmed in common with each other, but the list didn't include everybody who'd been farming in common. That could be because Augusta Young had made a mistake, or it could be that they deliberately left off, or she deliberately left off some people because they hoped to get title to the exclusion of others who had in fact been farming in common. But that would not be inconsistent with the evidence that was given. It would just mean that in 1995, a group of 31 of the, however many it was, 40 or 50 who were using the land, decided to try and get title for themselves. And the third possibility is that the claim was incorrect. It was made up. It was a story that was of recent vintage in 1995. In that case, it genuinely would be inconsistent with all the evidence that was given by all the witnesses. But this point was not put to the witnesses. They were invited to say, well, you can't have intended to possess in common because Tom and Millars said that only 31 people did, and you weren't one of the 31, or your family wasn't one of the 31. That's not the way that Eleuthera Properties put its case. Then we have Mitchell McPhee's affidavit, and most probable explanation of that, given the way he described the land that he was farming as being around where he lived, is he wasn't talking about property at all. He was talking about Millars. The other possibility is that he was striking out on his own. A third possibility, again, is that his evidence was genuinely inconsistent, but again, that wasn't the case that was put. Then coming on to 2010, and the fact that there were a number of adverse claimants in the 2010 petition. The way the cases were presented at the trial made it clear that everybody had the same understanding. As far as TMCL was concerned, their case was supported by the evidence of Mr. Barry McKinney, who's George McKinney's son. And in his witness statement in April 2013, which was long before TMCL and the association joined forces, that wasn't until October, I've quoted at paragraph 16 and 17 what he said. Then paragraph 17 is particularly important. It's my understanding from earlier discussions with the initial promoters of Tom and Miller. Tom and Miller was always established for the purposes of benefiting all the descendants of former servants and slaves of Anne Millar. Persons mentioned in paragraph 4 above were among the persons who were intended as ultimate beneficiaries. The list of intended beneficiaries was to be expanded in due course to include all beneficiaries. And that wasn't challenged in cross-examination either. As to Gary Young and Emily Hall, when they gave their evidence, they made it clear that they understood that they were claiming as descendants and had to share the land with other descendants. So there's nothing inconsistent there. And then the Boston Wileys, they also said the same thing, and we've set out a quotation from their evidence on page 4. Bristow Wiley was asked this question: please make it clear for me you are claiming the entire property the subject of this petition. I am claiming to be a part of the entire property, yes. So when you say you are part of it, so who else is a part of this? The legal descendants of Anne Millar, her servants. So do you consider your claim any different from that of my client, the Bannerman, Town Miller and John Miller's Eleuthera Association? Not really, no. All of us are descendants. And those who can prove themselves to be descendants, they are entitled according to the will as anyone else. And Dora Boston Wiley, question: you know why you are here in this court? Yes, I am an adverse claimer who is here basically to state that the land in question belongs to the descendants of Anne Millar, the former slave, or just the descendants and servants? Former slaves and servants. Miller, yes. Now you are a descendant. Yes, I am. So, in our respectful submission, in circumstances where there was uncontested evidence from a number of witnesses that they believed and their families believed they could use the land as descendants, backed up by the pre-1959 conveyances, backed up by the Gazette, inherently credible, the mere fact of the adverse claims having been made was nothing like sufficient justification for the judge to make the findings that she did. No rational process could have led her to the conclusion that she ended up at. The feud, my learned friend didn't really seriously attempt to defend that, and it can't be defended as a factor justifying the outcome that she arrived at. So in paragraph 23 overall, we say that the judge misdirected herself, that she ignored the evidence of numerous witnesses as to their intention. She ignored the documentary evidence from the 1950s. She gave decisive weight to material which was, at the very least, capable of an explanation consistent with the evidence that had been given. This is an evaluation of the evidence that was thoroughly flawed from beginning to end. We do invite the board to set it aside. It is not saved by the evaluation of the President, which was premised from beginning to end on the assumption that there needed to be an agreement. The concept she keeps coming back to. And the reason she rejects the evidence that gives very strong support to the association's case is because she says it's not capable of evidencing an agreement. My learned friend says that Justice of Appeal Adderley didn't confront the difficulties in setting aside the learned judge's assessment of the evidence. Well, he most certainly did. He examines the judge's evidence, says that the reason she gives for rejecting the evidence don't withstand scrutiny, points out that she hasn't looked at a number of very important pieces of evidence, makes his own assessment, and arrives at what we submit is, in fact, the only reasonable conclusion in this case, which is that the individuals who were extensively farming this land in the 40s, 50s, 60s, 70s, did so with the joint and communicated intention that they were entitled to do so as the descendants of Anne Millar. My learned friend has referred to 4 pieces of evidence. He's trawled through the thousands of pages of material that we have, and he's come up with 4 things that weren't in fact relied on by the judge or the President to support their conclusion, which he says the board should take into account in evaluating the evidence. The first is George McKinney's affidavit in 2008. My learned friend says that is inconsistent with the Tom and Millar petition. Well, so it is. It's a very odd document, and it was made when he was very elderly, and it's pretty clear if one looks at it in the light of what Barry McKinney said when he was asked about it. He was just talking about the wrong property. He was talking about land at Millars. Then there's Manasseh Mackey's affidavit in 1996, which deal with at paragraphs 26 and 27, where Mr. Mackey said he was laying claim to 60.63 acres of land. Unfortunately, we don't have the plan he referred to, so we don't know where it was. But we do know where Mr. Mackey was in at a much later point in time, in the 2000s, because we have Mr. Fernandez's plan. He was up in the Northern Bowls land. And it's quite possible that what happened here is that what happened is that Mr. Mackey saw an uncoloured copy of the plan that TMCL were relying on. The one in the record at page 2064 is uncoloured. And he may have thought that the TMCL petition included the Northern Bowls land. Certainly that seems to be what everybody thought during the trial. In fact, it's not the case, but if he thought that, then it's perfectly understandable that he put in an adverse claim, but doesn't really tell one anything about the 1,700 acres or the rest of the Gift 2 land. But even if the 60.63 acres was on the property, the claim is not conclusive evidence against a general belief in co-ownership for the reasons I have already submitted. And he may just have been making it up. He just have thought he'd have a go if he could get the land for himself. And it suited him to controvert the concept of joint occupation as descendants because he wanted to get the land for himself. Doesn't mean he was right. Then we have Errol McPhee's witness statement and Daneria Butler's evidence about the use of the land. My friend relies on his last 2 points. The evidence of the association's witnesses was that the residents of the local settlements were regarded as descendants. Mr. McPhee said in his witness statement of paragraph 21, the property was from my earliest recollection farmed extensively, particularly by the residents of Bannerman Town, Wemyss Bight, Millars, and John Millars settlements, hereinafter referred to as the settlements, who were regarded as descendants. Benjamin Martin said much the same in his witness statement of paragraph 4. The property was, from my earliest recollection and is related to me by elders in the community, extensively farmed by the residents and inhabitants of Millars and by those who later moved to John Millars, Wemyss Bight, and Bannerman Town, and their descendants, all of whom were considered to be the descendants of the former servants and slaves residing in Millars at the time of the death of the said Anne Millar. So there is nothing inconsistent in the evidence in the witness saying that the inhabitants of the local settlements farmed the land because they were regarded as being in the category of descendants. There weren't huge numbers of them. If one looks through the evidence, when people are asked to give a list of names, it's normally 10, 15, most 20 names. Then my learned friend relies on paragraph 30H of Errol McPhee's witness statement, where he said that he and his team had made a list of 25 persons who claim an interest by virtue of their occupation of the property, and then he refers to an exhibit, but as previously stated, no attempt was made to remove such persons from the land, or indeed prevent other local residents from occupying the property. Now, what my learned friend seeks to get from that is that what Mr. McPhee was saying is that there were people who weren't regarded as descendants who were nonetheless occupying the property. That paragraph needs to be read with another part of Mr. McPhee's statement, paragraph 20, where he says, notwithstanding the numerous conveyances recited by the petitioner, it is to be noted that following the execution of the same, no effort was made by the petitioner or its predecessors entitled to take possession of the property, nor to prevent persons from continuing to occupy and farm the land, all of which would add credence to the belief that Mr. Davis had abandoned his attempt to acquire the property and had indeed given a Christmas present to the several persons whose interest he had attempted to acquire. In the circumstances, there was no change in the manner of the occupation by the residents, including many of those who purportedly conveyed their interest to Mr. Davis. And if indeed they had conveyed anything to him, they had in all likelihood reacquired the same by virtue of their continued occupation since the date of their respective conveyances. That's what he's talking about in paragraph 30, subparagraph H, when he says, as previously stated, no attempt was made to remove such persons from the land. And the list that my learned friend is relying on is in bundle 2 at page 907. Turn that up, please. list headed persons who occupied the land over the years, and over the page there's another list headed persons unknown, saying how related to property none. If one looks at the list on page 907, the second person on the list is Samuel A. Young, who occupied a portion of land for 72 years. He was the person who executed the conveyance that I showed the board yesterday, the one which is in bundle 3 at page 1086. And in that, as the board may remember, he said he claimed to be the great-grandchild of Scipio Miller. So he clearly was somebody who was both occupying the land and claiming to be a descendant. The third one can see down that it says great-grandchild of Daphne Wemyss, so somebody else who clearly wasn't just occupying the property without claiming to be connected in any way to the will. We've been through this list. The only conveyance we can find in the record which relates to one of these people, where they don't say that they claim to be a descendant, is number 299, young Samuel O. And if I could ask the board to look at bundle 7, page 3798.
Sorry, the page number again?
Page 3798, my lord.
Thank you very much.
Volume.
Volume 7. And at line 7, the question is, what about Joseph Delancey? Was he a descendant? To the best of my knowledge, yes, ma'am. Do you know Samuel O. Young? Yes, ma'am. Was he a descendant? Yes, ma'am. And indeed, there's evidence elsewhere that Samuel O. Young was Gary Young's grandfather. This is Mildred Young giving evidence. So, Lord, he may not have said in his conveyance that he was a descendant, but he was. So there's really nothing in this point at all. What my learned friend also referred to was a short passage in re-examination of Mr. McPhee, paragraph 36 of my note, where Mr. McPhee said they have no relationship, they just occupied the land for a period of time, they had no relationship here. Page 136, persons unknown, these persons in that abstract, they just didn't state no relationship to the property at all. Mr. McPhee must, in my submission, have been referring to the list on page 908, the persons unknown list, and not to the list of people who are in occupation on page 907, because we've seen that they were descendants. So, Lord, we do invite the board to find that the evidence was only reasonably capable of supporting the conclusion arrived at by Justice of Appeal, which is that the individuals who were farming the land did so believing that they were entitled to do so in common as descendants under the will. Where does that take one? Then we come on to the question of law. And this is of importance, not only for this case, but for other cases in the Bahamas. This concept of generation property is one that is commonly held in the Bahamas. My learned friend says it's like a common law marriage and has no legal effect. And we submit that the board should seek to avoid that result. Or should seek, if possible, to legitimise people's reasonable expectations about their rights. And this is at paragraph 38 and 39 of our note that we make this point. My learned friend says, with unincorporated associations, the courts have these are my words, not his, but they have moulded or bent the rules of property to ensure that the understanding that people have when they join and give property to unincorporated associations is given effect to in law. And my learned friend showed a passage in Conservative Association Borough where Justice Brightman was doing just that, just finding a way of making it work as a matter of law. And that is exactly what the courts ought to do. The courts ought, so far as possible, to vindicate people's reasonable expectations, if it can be done without breaking as opposed to bending and moulding principles of the common law. So, can that be done with the generation property situation? In my submission, it can and should.
What do you say is the status of, I mean, you say that there is a rule, that there is a category of ownership with these characteristics called generation property. Now, if that is a rule, what is it? It's not a rule of common law, it is a rule of custom.
No, the way we put it is, putting it at its simplest, if you have 20 people farming land, believing they're entitled to do so because they are descendants of...
I mean, I understand how you say that the concept would apply here if it exists, but what is the basis on which you say it exists? Do you say that there is a custom to the effect that such a species of property is possible? Do you say that there doesn't seem to be any common law concept of that kind? So what's the juridical basis of it?
The juridical basis we submit is simply possessory title. And possessory title can be made to work without having to break any rules of the common law, simply adapting and applying well-established principles of the common law to a situation which hasn't occurred in England and Wales, has occurred in the Bahamas, and very similar situations have occurred in other parts of the world. In Nova Scotia with the Afton Band of Indians case, in Canada with Bannerman people, and so on.
Well, I can see that there may be societies in which such a concept is accepted, but the only basis on which we could hold that it was accepted was that there's a dissenting judgment of Justice Adderley to that effect, and a lecture. It clearly didn't impress, the submission doesn't even seem to have been made to the trial judge. It does seem to have been made to the Court of Appeal, but there's no support for it in either of the majority judgments. So for us to declare that such a concept existed with what seems to be the minimal standard of investigation would seem to be rather a bold step for us to take.
Well, there are three sources of information about it, apart from what the witnesses said. There is a history book, which we've included an extract from. There is an academic paper by Nicola Bethel, and there is the judgment of Justice of Appeal Adderley. And my learned friend's own submission, he says it is a concept in the Bahamas. He says shouldn't...
He doesn't say that it's illegally recognised.
No, nor am I submitting that it is illegally recognised. I'm submitting it's an understanding that people have, and the evidence in this case showed it's the understanding that applied here. And I'm making a submission that if it's possible to do so consistently with the principles of the common law, the court should give effect to it rather than just saying, well, never mind what people think. And my submission, it's not difficult to do.
It's simply a factual background from which one should infer the necessary consensual arrangements.
Yeah. Precisely, Lord.
Right.
We have set out our submissions in writing, and I suspect that time won't allow me to develop them, but if I could just summarise it briefly. At its simplest, you have a group of people using the land in the way that an ordinary occupying owner would, believing they're entitled to do so in common, because they are descendants of either one common ancestor or a family. Are they in joint possession? We submit they plainly are. All the requirements for joint possession are there. That gives rise to no difficulty. If the same group of people remain there for limitation period, they will collectively acquire, they have a possessory title throughout, and by the end of a limitation period, the right of anybody else to evict them will be gone. So that doesn't give rise to any difficulties. And that indeed was the analysis of Justice Jones in the Afton Band case. He said that the members of the band who were on the reserve during the period when the land in question was being used had acquired title to it as tenants in common. The difficulty with that analysis is it doesn't really reflect the reality that people will come and people will go. And our submission is that that aspect of how the land is used ought to be dealt with in this way. If an individual squatter hands over the land he is possessing to another squatter, cedes possession, there is no conveyance of title. That's why there's no need for a deed. Squatter A cedes possession to squatter B. Squatter B has a title by virtue of squatter B's possession. He doesn't acquire squatter A's title. There's no need for a deed. As against the paper title owner, the continuous possession of the two squatters is added together, and at the end of a limitation period, the paper title is extinguished. And on this basis, the last squatter who is in possession at the time that the question arises is the one with the title. That's exactly how Mr. Justice Foss analysed it in the Ferndown case. And there is an Australian decision called Mulcahy and Curramore, where it's explained very clearly by Chief Justice Bowen how successive squatters work. And if the board wants to look at just one authority on the point, that would be the one I would suggest to look at. It's at page 8769. That concept has not so far been applied to group. But we submit it works perfectly well with the group. Each time somebody new joins the group, is admitted by the existing group. It's up to them whether they accept them or not. If they consider they're entitled to come onto the land and start using it, then they are. And once they're on the land and using it in common, they become part of the group. And they acquire an undivided share in the possessory title. And if somebody leaves, then in the same way that a squatter who cedes to another squatter loses their possessory title because they've abandoned possession, the same must be true of somebody who leaves the group. And in that way, possession and title is vested at all times in the group of individuals who are actually using the land. If one gets a situation where one by one they leave and only one of them is left, then that one person has it. And of course, he can't be compelled to make it available to other people who might in equity be regarded as entitled to it. I say in equity, in fairness. But in practice, he may well do so. She may well do so. The other question, of course, is what if somebody who is part of the group, who would have been entitled if there'd been a valid devise or a valid conveyance, can they come along and start using the land as of right? We did make a submission that that might be possible under the principle explained in Cook and Littleton. But we can see it gives rise to difficulties. It does add an additional layer of complexity to the analysis if one allows that possibility. It would mean, in a situation like this, somebody who'd been living in Miami who can turn up at the land and say, well, I'm a descendant of the freed slaves of Anne Miller, so I can come onto the land. And the people there, if the people there say, yes, that's fine, then of course there's no problem, because then they start using the land and then they're in joint possession. The problem arises if the people on the land don't want them to come and say, no, we don't recognise you. And it may well be that the simplest solution is to say, in that sort of situation, it's up to the people on the land. They're the ones who are in control of the land. They're the ones who are in possession. It's up to them to decide whether to admit or not admit somebody who claims to be part of the group. And if they say yes, then that person becomes part of the group and acquires a joint possessory title with them. So in that way, we submit it's possible to give legal effect to the concept of generation property to the extent that it exists, without breaking or even bending any of the established principles of common law and title to land. My learned friend said there was a problem because title is being passed without a deed, but that's not what's happening, as I've tried to explain. Lord, in relation to the question of paper title, I think I've addressed this already, but just in case I haven't, in paragraph 2, we have explained why it was impossible for any of the pre-1959 conveyances to give any title to Mr. Arthur Vining Davis. The principle is you can't convey an undivided interest in part of the land, and even if they could, because Arthur Vining Davis did absolutely nothing on the land, time would have run against him immediately. The ink was dry on the conveyance, and 20 years later his title would have gone.
Very grateful. Well, the board is extremely grateful to counsel for their very helpful submissions in an extremely difficult case. We will take time to consider what advice we will humbly tender to Her Majesty.